Hello again, class, and welcome back. This week we're going to talk about Chapter 10, Policing and Law. As I've stated in a previous video, that we as police officers also have to abide by certain laws and regulations to protect you, not only to protect you from uh, crimes of other things, but also to protect you from misconduct from police. And one of the things that kind of polices the police is a couple of amendments, the 4th, 5th, 6th, and 14th Amendments to the United States Constitution. First of all, we're going to talk about the 4th Amendment. And the 4th Amendment basically states that you are protected from unreasonable searches and seizures. Now, you say, well, why would I be searched and why would I be seized? Well, anytime you come into a traffic stop, you could be seized at that particular moment, and you could be subject to search. Um, as long as you cooperate with the officer and do what they say on a normal traffic stop, they're going to issue a ticket and move you right along. But if the officer has some type of reasonable suspicion or probable cause to suspect that some type of crime is afoot, under the 4th Amendment, your rights are kind of out the door at that particular moment. The 4th Amendment protects you from unreasonable search and seizure, but it does not protect you from all search and seizures. And at that particular moment, the officer has some type of probable cause or reasonable suspicion that some type of crime is being taken place, and therefore you are at that point seized for further investigation. Most of the time it will involve some type of search. Now, the one thing about searches is the officer, if you're in a vehicle, can only search within your wingspan. So if you guys would, just kind of imagine putting your arms straight out, level on each side, and just kind of going in a 360 degree. That's about all the officer can search in that particular moment. Now, if you are under arrest, there is a thing called search incident to arrest, which means the officer can search anything and everything. Um, those are mostly for police departments who have some type of standard operating procedure for vehicle searches, vehicle inventory, things of that nature. So just because you're protected under the 4th Amendment for unreasonable search and seizures does not prevent you from being completely searched. As I've stated before, with the search and seizure, the officer has particular areas in which he can search and which he cannot search at particular times. But the officer must have some type of probable cause. And probable cause basically is the facts and circumstances within an officer's knowledge and of which they have reasonably trustworthy information that is significant to warrant a prudent person in believing that someone had committed or is in the commission of an offense. So in other words, an officer believes that you are transporting marijuana or you have an illegal weapon or something like that. That is basically what comes down to probable cause. Then we're going to get into stop and frisk. Under stop and frisk, an officer can stop anyone at any time, talk to them, and they can ask for permission to search that particular person. Now, if the officer has articulating circumstances such as reasonable suspicion that that person has some type of weapon or could possibly be armed, under Terry versus Ohio, this basically states that a person can only be stopped and frisked if there is reasonable suspicion that there is something going on. We often refer to this as a Terry stop. We don't usually refer to it as a stop and frisk. It's often referred to as a Terry stop. Either way is acceptable, stop and frisk or Terry stop, but most officers refer to it as a Terry stop. basically because of the court case, Terry versus Ohio. Another thing that we want to talk about is different types of searches. We have those searches that are based on exigent circumstances. Exigent circumstances are those circumstances in which an officer is possibly in what the courts refer to as hot pursuit, and the officer does not have time to evaluate the situation. The person could possibly be trying to dispose of weapons, drugs, and things of that nature. And during those particular times, exigent circumstances exist for the officer to perform a search of the person or the area. Other things that can also aid in an officer is the plain view search. And plain view search basically means that the officer sees something, then the search can be established. This is more often the case with officers on vehicle stops. They will either see a weapon, they'll see drugs, something like that. And at that particular point, the officer has the right to tell the person to get out of the vehicle and initiate the search. A lot of people say, well, you can't go into the vehicle and you can't do this. Well, an old saying in the academy was the eyes can't trespass. I've always believed that if you can see it, it's not trespassing in any form or fashion. So plain view doctrine is basically when you see some type of illegal activity or illegal evidence, then you can search that vehicle or person. And then we have consent searches. Consent searches are those with permission from the person to search the body of or the vehicle of. And in those particular cases, the officer probably has some type of probable cause for asking, or they wouldn't ask for a search. And in those particular cases, most of the time, if you don't have anything, you're more than likely going to be issued a ticket and sent on your way. The next thing we want to talk, we've already talked a little bit about probable cause. Next thing we want to talk about is confessions and interrogations. Most everybody knows that confessions are freely given to officers without any type of coercion. The one thing that helps and aids law enforcement and the citizens as a whole is something that we should all know, is our Miranda warnings or our Miranda rights. And up until this court case was established, officers didn't have to read Miranda warnings or Miranda rights. They could just arrest the person and start interrogating the person without the person giving any type of information or even knowing that they don't have to talk to the officer. Under Miranda, it basically states that anything you say can and will be used against you in a court of law. You always have the right to an attorney, and if you cannot afford an attorney, one will be appointed to you. One of the things that we always did at the police department is we had these on cards. It was always held up better for us, or we believed that it held up better if we read it straight from the card. But most everybody has that memorized. And everybody thinks that, oh, well, if I'm on a traffic stop and I get a ticket, or if I'm arrested for no driver's license or suspended license, well, they didn't read me my rights. Well, they don't have to. Really, the only time that you have to be read your Miranda rights is if you are going to be interrogated for any particular crime, and most of the time those crimes are going to be felonies. So you don't have to be read the Miranda rights every time you come in contact with a law enforcement officer. And then we have the Fifth Amendment, and the Fifth Amendment basically states that you have the right not to incriminate yourself. So therefore, under Miranda, you have the fifth. You can plead the Fifth, which basically states, look, I'm not going to talk to you. I don't have anything to say. Where's my attorney? That's what most folks say. So under Chapter 10, we're going to learn a lot about police issues, police mandates, things you can and cannot do. So please read up on Chapter 10, and thank you for listening, and I hope you have a great day.